Welcome back, brothers and sisters. I am Braden. This is Langley Outdoors Academy, the place where we not only talk about what's going on in the gun world, but we also discuss how we're going to fix it together. Now, the content that I'm about to show you is coming from something that I'm sure you've heard about. The red flag laws were ruled unconstitutional in New York. However, what I'm about to walk you through is the actual verbiage used by the judge in New York, which points out the fatal flaw across the board nationally with red flag laws and does a terrific job tearing it asunder. Everything will be linked in the description box below, and I cannot wait to hear what you guys think about this one. And if you are a new viewer or a returning viewer, please consider giving this video a like, hitting that subscribe button, making sure that notification bell is on. We need as many people as we can to get inside the fold, help us in our quest to pass the Second Amendment along to the next generation, and thank you so much in advance for your consideration. Now, SDI is the sponsor of this video. I'm going to say a few words from them, and then we are going to hit it. Now, I know a lot of you out there like to modify and upgrade your own guns. And if you're looking to turn a hobby into a career, SDI, Sonora and Desert Institute, can help. Their online programs cover everything from gunsmithing, ballistics, woodworking and finishes, shooting sports management, and more. Plus, all the tools and materials are shipped directly to your door. There's never been a better time to turn a hobby into a career, so what are you waiting for? There's a link in the description box below, and thank you so much to SDI for making this content possible. But my brothers and sisters, one of the things we hit consistently on this channel is the fact that red flag laws are the most unconstitutional violation of rights of the citizens of the United States that exist out there right now. You've got the infringement of the Second Amendment, of course, that's very bad. You have the violation of due process rights, of course, very bad. All combined into one egregious action called red flag laws. Now, this is just the beginning baby steps of ruling it unconstitutionally nationally, but let's continue. I've got to walk you through what happened in this New York case, because yes, I know you guys may be aware of it, but what he said is crucial. This is from New York Supreme Court Justice deems New York red flag laws are unconstitutional. This is from December 30th, and this is how you start our weekend or a year off right. All right, let's get into this. The court also noted that many safeguards of due process that the state had in other analogous situations did not exist in New York's red flag laws. For example, the court noted that red flag laws and the New York mental hygiene law use the same definition for likely to result in serious harm. However, under the New York mental hygiene law, those determinations are made by a doctor, a person licensed, trained, and experienced in making such determinations. However, in the case of New York red flag laws, most of the authorized petitioners are not doctors and are not licensed, trained, or experienced in making that determination. Under the mental hygiene law, 2 doctors are required to make the determination if a person's liberty is to be taken away for more than 48 hours. No such safeguard is required. Not even 1 doctor is required before a person loses their gun rights for 1 year. That is so crucial, drawing the juxtaposition between the mental hygiene law in New York and the red flag laws. They are dramatically different. That is going to be a weak flaw going forward as we continue this, because you're going to see this bolster more attacks against the red flag laws because they are incredibly unconstitutional. They violate due process laws, and they don't even require a single expert to do so. And in any other case, that's still not okay. But let's continue, because this judge did a phenomenal job laying the groundwork for 2023 and beyond. Another example cited by the court is under Article 10 of the Mental Hygiene Law, which permits civil detention of certain dangerous sex offenders after they have served their sentence. However, before a judge can civilly detain someone under the statute, the convicted sex offender is entitled to a court-appointed free attorney, a state-funded psychiatrist to assist in the defense, a probable cause hearing within 30 days, and ultimately a full jury trial before the convicted sex offender's liberty can be taken away. The court pointed out that none of these protections exist in New York's extreme risk protection order laws. Again, you have no right to representation. You have no right to face your accuser. You have no right of a trial in extreme risk protection orders. The hypocrisy and the violation of rights is so staggering when it's put up against existing criminal convicted people. It falls apart. It's incredibly important to understand as we go forward. This is the stuff that we need to be fresh up on. This is the stuff that we need to send out, because this right here is how you defeat red flag laws. And I got one more thing for you, and then we are going to enjoy the beginning of our 2023 together. The court pointed out that where mental health issues have formed the basis for a loss of fundamental constitutional rights in the past in New York, the laws have always provided a number of substantive and procedural due process protections, none of which are afforded under the New York ERPO laws, or Extreme Risk Protection Order laws. The court reiterated a statement from the Supreme Court: the Second Amendment rights are not a second-class constitutional right. And the reason I put that in there is two reasons. One, they're always provided a number of substantive and procedural protections of those constitutional protected rights that exist in extreme risk protection orders. And the second thing right there, that last sentence, they are not a second-class constitutional right. You know where you've heard that before? You've heard that before in the court cases with 18 to 21-year-olds not having the ability of their Second Amendment rights because they've been deemed immature. They are not second class. You also heard it with Justice Clarence Thomas when he said the Second Amendment is a second-class is not a favored right in the United States Supreme Court. It's a second-class right. We are seeing this continually pop up over and over and over again, and we're going to gain momentum from it because it's so applicable. That's what I've got for you guys. Let me know what you guys think in the comments field below, and I will see you on the next one. I'm Braden. See you later.